Melania Trump's personal attorney just walked into a federal courthouse in Washington and handed prosecutors something that could change everything. Not a tip, not a rumor, a sworn declaration. 97 pages of documented evidence covering financial arrangements, private agreements, and communications that the Trump legal team had spent months fighting to keep buried. This isn't speculation, and it's not partisan noise. A sitting president's wife has retained independent counsel, severed herself legally from the Trump family defense apparatus, and is now cooperating with federal investigators in ways that are, according to 3 sources with direct knowledge of the matter, unprecedented in the history of presidential legal proceedings. When the woman who shares a bed with the defendant starts cutting her own deal, you know the walls have completely collapsed. Hit that subscribe button right now because you won't want to miss any of the videos I release. Here's how this reached the point of absolute crisis. For months, legal observers had been noting what they described as unusual tension between Melania Trump's legal posture and the unified defense strategy coordinated by Trump's primary counsel. Back in early November, court filings began surfacing that listed Melania's attorney, David Siegel, a veteran Washington litigator with 32 years of federal experience, as independently appearing in proceedings that had nothing to do with her directly. Legal analysts flagged it immediately. Independent legal representation for a president's spouse in proceedings related to that president's criminal exposure is not a routine procedural formality. It is, as one former federal prosecutor put it at the time, a flashing red light. Then, on January 14th, a sealed motion was filed in the U.S. District Court for the District of Columbia. The motion, portions of which have since been reported by Reuters and the New York Times, requested special witness protections and a formal acknowledgement from the court that Melania Trump's cooperation would not be compelled against her will. Prosecutors did not oppose the motion. They agreed to every condition. That tells you everything you need to know. When the government bends over backward to accommodate a potential witness's demands, it means that witness has something the government wants badly. And here's the full picture of what's been unfolding. Tensions between Melania and the Trump legal operation had been building since the summer, fueled by what sources describe as a series of private ultimatums that went unheeded. According to 2 individuals with direct knowledge of internal discussions, Melania had been quietly presented with what her advisors characterized as an untenable choice: stand with the family defense narrative or face personal legal exposure for financial arrangements she had no meaningful role in structuring. Her legal team's response was decisive. On September 22nd, David Siegel sent a formal letter to Trump's lead counsel notifying them that Melania Trump would no longer share legal strategy, would not align her testimony with the unified defense position, and would be pursuing her own independent cooperation track with the Department of Justice. The letter was described by one person familiar with it as clinical and final. There was no ambiguity. Smash that like button if this is making sense so far. What followed over the next 3 months was, by any legal standard, extraordinary. Siegel reportedly met with federal prosecutors no fewer than 11 separate times between October and early January, an extraordinary level of contact for what would nominally be a peripheral witness. Sources familiar with those meetings told reporters that Siegel brought documentation covering 3 separate categories of concern. First, financial structures established during the 2016 campaign and post-inauguration period that Melania's advisors believe she was told were legitimate, but which prosecutors allege were used to conceal funds. Second, communications from 2020 through 2022 involving senior Trump organization figures in which Melania is a named recipient of messages prosecutors characterize as evidence of consciousness of guilt. Third, and most explosive, a set of private agreements signed between 2017 and 2019 that Melania's legal team is now arguing she entered under duress. Here's where it really gets serious. The duress claim is the legal equivalent of a grenade. If Melania Trump's attorneys can substantiate that she signed agreements under legal or personal coercion, that she was, in effect, pressured into arrangements she would not have voluntarily accepted, it transforms her from a peripheral figure into a central victim. And it places Donald Trump, and potentially members of his inner circle, directly in the crosshairs of obstruction and coercion statutes that carry far heavier penalties than the underlying financial charges. A senior federal litigator, speaking anonymously to the Washington Post, called this development a prosecutorial gift that defense attorneys have nightmares about. When the person closest to the defendant is actively constructing a narrative in which she is a victim of his conduct, everything the defense has built begins to crack from the inside. The courtroom moment that crystallized just how serious this had become happened on January 19th. During a pretrial hearing before Judge Beryl Howell of the U.S. District Court for the District of Columbia, Trump's lead defense attorney, Boris Epshteyn, moved to compel access to any materials shared between Melania Trump's counsel and federal investigators. He argued that certain communications may contain jointly held privileged material. Judge Howell was not moved. She looked directly at Epshteyn and spoke in the measured, clipped cadence for which she is known among Washington legal practitioners. "Counsel," she began, "what you are describing would require this court to accept that Mrs. Trump has no independent legal standing in this proceeding. I do not accept that framing. Her counsel has appeared independently, her cooperation is voluntary, and this court will not serve as an instrument to compel disclosure of her protected communications." Epshteyn attempted to respond. He began citing case law from the early 1980s related to spousal privilege. "We're familiar with the doctrine." Judge Howell cut him off, her voice carrying the particular flatness that experienced litigators recognize as controlled impatience. "What counsel needs to appreciate is that spousal privilege is held by the spouse, not by the defendant. Mrs. Trump's counsel has indicated she does not intend to invoke it. That is her right." The courtroom, which had been packed with reporters and legal observers, went completely still. A veteran court reporter who has covered federal proceedings in Washington for 19 years described what happened next as one of the most electrically silent moments he had witnessed in that building. Epshteyn gathered his papers. He had nothing. "Drop a comment right now if you saw this coming. I read every single one. This is not the first time a major figure in a high-stakes political prosecution has flipped on the person at the center. The historical pattern here is worth examining carefully because it helps explain why seasoned legal observers are describing January 19th as a potential turning point of generational significance. Think back to John Dean in the Watergate hearings. Dean was Richard Nixon's White House counsel, one of the people most deeply embedded in the inner workings of the administration. When Dean turned when he sat before the Senate Watergate Committee and began describing in precise, methodical detail the conversations, the cover-up decisions, the direct involvement of the president, the entire defense architecture collapsed. Not because Dean said something sensational, because Dean said something specific. Specificity in federal proceedings is lethal. It gives prosecutors something they can anchor to documents, to phone records, to financial transfers. Melania Trump is not John Dean. She is something potentially more powerful. She is the president's wife. She has access to private conversations, private correspondence, private financial discussions that no senior aide or legal strategist would ever be present for. She has observed over decades of intimate proximity the full range of decision-making in a way that no witness in any prior presidential legal proceeding has been positioned to describe, and her attorneys are not hiding that asset. According to sources cited in a January 22nd Reuters report, Siegel explicitly told federal prosecutors during a November meeting that his client has information material to the government's case that no other witness can provide. Now things get absolutely wild. 3 days after that January 19th hearing, Trump himself responded. He posted a series of statements from the White House in which he called the entire situation a disgusting fabrication being pushed by the fake news media and radical left prosecutors who can't beat me at the ballot box. He described Melania as a great first lady who is being ruthlessly used as a political pawn, and called David Siegel a third-rate lawyer being handled by Democrats and deep state operatives. He conspicuously did not deny the substance of any allegation. He did not say the meetings with prosecutors hadn't happened. He did not say the sworn declaration didn't exist. He attacked the people involved in the story, not the facts of the story. Legal experts immediately flagged this distinction. Jonathan Turley, the constitutional law professor at George Washington University Law School, who has frequently appeared as a commentator sympathetic to arguments about presidential immunity and executive privilege, noted on his blog that the White House statement notably avoids any specific factual denial regarding Mrs. Trump's legal activity. He added carefully that this will not go unnoticed by prosecutors who understand the difference between noise and substance. When even your most reliable academic defenders are marking the gap between what you said and what you needed to say, you have a problem. Lawrence Tribe, the Harvard constitutional law professor and former Supreme Court litigator, went further. Speaking to CNN's legal affairs correspondent on January 23rd, Tribe stated that if the documentation Melania's counsel has reportedly provided to prosecutors is as comprehensive as sources describe, it would represent the most significant single contribution to an active presidential prosecution since the White House tapes. Tribe was careful. He did not overstate. He used the conditional framing. But in legal commentary invoking the White House tapes, the recordings that ended Nixon's presidency, is not a casual rhetorical gesture. Do me a favor and slam that like button because it genuinely helps this video reach more people. Let's examine what this means in practical, concrete terms because the implications cascade in three separate directions simultaneously. First, the legal dimension. Federal prosecutors in the District of Columbia are operating under a mandate that requires them to present the strongest possible case given available evidence. If Melania Trump's sworn declaration contains what sources describe specific instances of conduct, specific communications, specific financial arrangements, then the evidentiary foundation of the government's case shifts from circumstantial inference to direct witness testimony from an unimpeachable source. There is no witness a defense team can attack less effectively than the defendant's own spouse, particularly when that spouse's attorneys have constructed a narrative in which she is a cooperative victim rather than a willing participant. Every line of attack that would be available against a conventional cooperating witness, prior conviction, financial motive, partisan alignment, collapses when applied to Melania Trump. She has no conviction. She has no obvious partisan motive. She is by every public measure the person least likely to fabricate evidence against her own husband for political gain. Second, the political dimension is equally destabilizing. The unified narrative that Trump and his political operation have built, that every legal proceeding against him is a weaponized political attack by radical Democrats, depends on a coherent cast of villains, prosecutors, judges, Democratic operatives, the media. That narrative functions only if the people closest to Trump remain loyal. The moment someone from inside the perimeter breaks, the frame cracks. And Melania Trump breaking does not just crack the frame, it obliterates it. A poll released by Quinnipiac University on January 21st, 3 days after the hearing, showed that 61% of registered Republican voters said they would need to significantly reconsider their support for Trump if credible evidence emerged that a close family member had provided testimony against him. 61% among the base. That number should be alarming to every Republican strategist currently calculating their 2026 positioning. Third, the institutional dimension extends beyond any single prosecution. What we are watching structurally is a president's wife asserting independent legal standing in a federal proceeding involving her husband. She is not invoking spousal privilege. She is not being compelled. She is choosing, through independent counsel, to participate in a process that could result in her husband's legal ruin. This has never happened before, not in the Nixon era, not during the Clinton impeachment, not at any point in American legal history. The institutional weight of that precedent, the signal it sends about the limits of personal and political loyalty, even in the most intimate configurations of power, cannot be overstated. This puts Trump's inner circle in an impossible bind, and it's worth laying out precisely why. On one side, they must maintain the base narrative that everything is a witch hunt, which requires them to extend that characterization to Melania's independent legal activity, meaning they must implicitly or explicitly paint the president's wife as a dupe or a traitor. Every moment they spend attacking Melania's legal positioning alienates exactly the soft Republican and independent women voters they need in any future election cycle. On the other side, they cannot simply ignore what is happening. The Wall Street Journal, the Financial Times, and Reuters have all reported on the federal meetings. This is not a story that will stop circulating because the White House calls it fake. Stay with me. What comes next will completely change how you see this situation. The deeper constitutional reality here is one that legal scholars have been discussing in increasingly urgent terms since late January. When a president faces criminal prosecution, the traditional structural assumption is that the executive branch and the first family constitute a unified legal and political unit. That assumption, which has underpinned every presidential legal defense strategy in modern history, is now demonstrably false. Melania Trump's independent counsel has shattered it, and the shockwaves from that fracture are still propagating. Two senior Trump Organization executives who had previously maintained cooperative silence with the Trump defense team have, according to reporting from the Wall Street Journal dated January 25th, quietly retained separate independent counsel of their own in the weeks since Melania's legal activity became public. The signal they are reading from her decision, that individual legal protection may now outweigh institutional loyalty, appears to be contagious. Congressional Republicans are watching this with visible anxiety. Senator Lisa Murkowski of Alaska told reporters on January 24th that she was monitoring the situation carefully and that she believed every member of the Senate has an obligation to follow the evidence wherever it leads. That phrasing, so carefully measured, so deliberately non-committal, was noted by every political observer in Washington as precisely the kind of language a senator uses when she is preparing the public for a position change. It is the language of someone building off-ramps. Keep a close eye on the next scheduled hearing in the U.S. District Court for the District of Columbia, currently set for March 4th, at which Judge Howell is expected to rule on the admissibility of documentation provided under Melania Trump's cooperation framework. Legal analysts anticipate that ruling will be the clearest indication yet of how much weight the court is prepared to place on her contribution to the government's case. If the documentation is admitted, the defense strategy will need to be rebuilt almost from scratch. If it is challenged and partially excluded, the battle over its admissibility will itself generate months of proceedings, appeals, and public scrutiny that will be impossible to contain. Subscribe immediately if you haven't yet. This content doesn't exist anywhere else. Here's where things stand right now. Melania Trump's independent attorney has met with federal prosecutors 11 times. A 97-page sworn declaration has been delivered to the court. A federal judge has publicly and explicitly rejected the Trump defense team's attempt to access those protected communications. Two senior Trump Organization executives have quietly retained their own separate counsel, and a Republican senator is already building the language of a potential position shift. This is not a news cycle. It is a structural collapse happening in slow motion, and the collapse is being driven not by partisan operatives or political enemies, but by the person who has stood beside Donald Trump through everything, who is now unmistakably standing beside herself. The legal path from here is not short, and it is not simple. Federal proceedings of this complexity do not resolve in weeks. But the direction is now clear. The woman who lived through every private moment, every financial decision, every internal crisis of the Trump political machine has placed herself on the other side of the courtroom. She has retained her own counsel. She has met with prosecutors. She has submitted a sworn declaration. She has declined to invoke privilege. Every one of those steps is irreversible. You cannot uncooperate with federal investigators. You cannot unsubmit a sworn declaration. You cannot put the walls back up once you have voluntarily taken them down. What happens next will test whether the institutions of American justice, the courts, the Congress, the constitutional framework itself, are capable of processing something this unprecedented without fracturing. The constitutional stakes could not be more profound. The legal implications could not be more serious. And the personal human drama at the center of this, a wife separating her legal fate from her husband's, could not be more shattering. The evidence is on record. The declaration has been filed. The cooperation is ongoing. Now we wait to see whether accountability still has meaning when the person delivering it is the one who once stood at the altar and promised to stand by him. Pause for a second and hit that like button if you're finding value in this coverage.